Man, I'm gone today. Mike has taken over the podcast. We've got new age music, and people are thinking, hey, why is Buzzkill back? Norm's back. Hey, welcome back to Law and Legitimacy, everyone. Took the day off yesterday to prepare for trial. Went in and did trial and going back today, but have fewer things to prepare for this morning. Mike, thank you. Thank you for stepping up and classing up the show. You know, I haven't had a chance to listen to it yet, but was it fun?
It was fun. I was, I had nerves at the beginning. It's always, interesting being put on the spot. And I think I started the show by just talking about how strange it was to be speaking into a screen with no one around, right?
Yeah.
So you've got these, you've got indicators of people in the chat talking. It was sort of a surreal experience. It felt unnatural in a way, but, made the adjustment and kept going. But had a good time, went for about 45 minutes. But we all missed you. I think Justin.
I don't know about that. I got about 45 messages saying, disappear, old man. Mike's the future. We all know that, but I'm going to enjoy the present while I can. And what a present we have. So it's Tuesday. Big events in D.C. yesterday. I'm getting reports from people who are close to the ground there. This doesn't come from clients. I'm not passing along attorney-client privilege information. But it is no mystery to those of you who have followed the January 6th prosecutions that there's a heavy concentration of January 6th defendants in the D.C. jail, in the District of Columbia lockup. Many of them are pretrial detainees awaiting trial. Some have been convicted and not sentenced, including my clients, the Proud Boys. The Proud Boys have had quite an odyssey. They were being held in Alexandria for a while. Then they were moved to a federal facility in Lewisburg, Pennsylvania. Now they've been brought back to the D.C. jail. They were in solitary for a while. And then they were put into a unit of all January 6 guys, J6ers. Many of them Proud Boys. And it is that's the unit that gets serenaded each night by people who are organized by Ashley Babbitt's mom, and they sing the national anthem and so forth. Well, into the unit over the weekend, apparently, was moved somebody widely regarded as an Antifa member. And those of you who don't follow these events may say, what's Antifa? Antifa is a loosely affiliated group of anti-fascists. The Antifa movement actually goes back to the 1930s in Franco's Spain, where people organized in efforts to oppose, if necessary, with violence, what they took to be authoritarian overreach and control within their society. It's largely regarded as a left-wing group, although why it is not always obvious to me. The reaction to authoritarianism can come from both the left and the right. There's right-wing authoritarianism and there's left-wing authoritarianism. In any case, Antifa and the Proud Boys have squabbled on the streets in recent years, and Antifa members have attacked Trump supporters. Proud Boy members have attacked Antifa or defended Trump supporters from Antifa attacks. So call somebody Antifa in the presence of a Proud Boy and you're asking for trouble. Call somebody a Proud Boy in the presence of Antifa. Similarly, you're asking for problems. The federal government, the FBI, has confidential human sources embedded in both organizations. The focus of prosecutions right now, however, is on the Proud Boys. A limited number of Antifa members have been prosecuted relating to January 6th. There are those on the right who think that this was a psyop. January 6th was a psyop. A psychological operation organized by the federal government and embedded by Antifa to justify an authoritarian crackdown. I just don't buy that narrative. I'm close to the investigation as a result of several cases, including the Proud Boys case. Some Antifa members were present on January 6th, and some did get arrested. Well, the geniuses in the federal corrections system placed an Antifa member in the Proud Boys unit sometime within the last 4 or 5 days. And they kept him in the unit, apparently visible to members of the Proud Boy, but in a holding cell for about 3 days. Over the weekend, they released the Antifa member after everybody had been wound up and jazzed up for a number of days. And apparently the guy got beat up. I don't know how bad the injuries were. I've received calls from people who have received calls from in the facility. But now the facility is cracking down on the J6ers, and they have moved this, according to Gateway Pundit, 13 J6ers, presumably out of the J6 unit, perhaps into solitary. I was told last night that they'd moved 13, and family members are calling frantically to find out whether their loved ones have been affected by this. I don't know is the answer. And I got a call from someone last night saying, what rights do these detainees have against arbitrary movements and assignments? And even if they weren't involved in the violence against the Antifa member, why are they being moved? And the answer is a disturbing one. It's not an answer that somebody's going to want to hear who has a loved one inside. And that is that penological interest, that is the judgment of corrections managers, wardens, and whatnot, are largely deferred to by the courts. Thus, in the First Amendment context, an inmate is still a member, is still present in the United States, obviously, and has constitutional rights, even if some of them have been taken away as a result, including the right to liberty as a result of their confinement, but they retain First Amendment rights. The courts, however, are very deferential on how the courts manage the First Amendment rights of prisoners. The lead case there is a case called Turner v. Safley, where the language is that the courts defer to the penological interest for safety. Similarly, with respect to the movement of inmates and the handling of violence, you may have noticed in the affirmative action cases that were decided a week or so ago in the Supreme Court, a discussion of when race can pass muster under strict scrutiny. And the answer is that it can pass muster when it's necessary to keep peace in a facility. Thus, there can be race-based classifications and movement of inmates on the basis of race to prevent racial violence. So I suspect that just about anything the DC jail does to move these guys is going to be justified within the eyes of the court. I think that if you've got a family member who's involved and they feel they've been moved inappropriately, they need to make administrative complaints within the agency. And once those administrative complaints are exhausted, they may or may not have access to federal court. I'm going to respond to Dawn Neal's comment. Ray says Antifa is an idea. There's a wonderful book that was written, and I can't remember the name of the author, about Antifa. And it is an idea. It is a loosely affiliated group. It's not a centralized organization to which people pay membership dues, and there's not a recognized leader. It's organized by design in a cellular structure around the concept of resistance to authoritarianism and resistance to what is loosely described as fascism. And so no two Antifa groups are identical. The groups may not know one another. And the reason for that is it makes it very difficult to prosecute them because there is no hierarchical organization. Contrast this with the Proud Boys, very much an idea. They are Western chauvinists. They're not going to apologize for creation of the Western world. But they did have a hierarchical structure and they did have a top-down organization. And the result of that was prosecution.
Well, I guess Norm likes to, here he comes.
Where did we cut off? I hit the wrong.
You just dropped out. So you were kind of halfway through the description of the book.
Which the Antifa book. So, Antifa is an idea loosely organized around the notion of resistance to quote unquote fascism, whatever that means. That's right-wing authoritarianism as far as they're concerned. And no two Antifa groups are organized cellularly. That is, there are cells in various locations. There are certain public indicia that make them identifiable. They typically wear black helmets or black masks, face masks, and black black clothing to make themselves unidentifiable. And so one of the great sports in the ideological warfare of our times is the right and left doxing one another, trying to determine the identity of an Antifa member and publishing it online. That's what I'll call that Civil War light, social media Civil War. Whether it emerges into something more violent remains to be seen. But in any case, I wanted to break the news about conditions in J6 land in the DC jail. If you have a loved one reach out to find them. Communications are going to be difficult right now. I doubt the DOC can even find each of these guys right now. My heart goes out to them, and I hope for the best for each. Lots going on around the country. Don't know where to turn next. North Carolina. I mean, our correspondent for Liberty in North Carolina, Mike Boyer, keeps coming up with these great North Carolina stories. And of course, his view is the epicenter of all that happens in the country is North Carolina. And maybe he's right. Two events in North Carolina this week strike me as operating in opposite directions, but they show the contested terrain of our times, and both involve North Carolina State. One
is the UNC system more broadly. What I have on the screen is the Fourth Circuit ruling against a North Carolina State professor.
I misunderstood the other as to UNC more broadly. Let's deal first with the Fourth Circuit case. So a professor, a statistician, decides, I guess his name is Stephen Porter,
yep.
That the university's reliance on DEI, diversity, equity, and inclusion standards is diluting the standards for selection of people. In other words, some people who are less competent are being hired to perform jobs simply because of their identity. And he opposes this, and he points it out and has been outspoken about that. He ends up disciplined. What adverse action did North Carolina State take?
So Professor Stephen Porter is part of the education department at North Carolina State University, in particular the math education department. And for those of you who are not familiar with North Carolina State University, in terms of its biological sciences, math education, and engineering, it is among the elite, or is regarded as among the elite in the country. So as a doctorate level professor, he was a part of a group of programs, and he was, teaching classes, but also mentoring or being an advisor to doctorate candidate students. And the issue central to this case is his action, I think it was a First and 14th Amendment action, and he was basically saying he wasn't terminated, professor, but he was being stripped of his role within a certain group within this doctorate level program. He was being excluded from certain department events, coordinating events, all these sorts of things. He had just been stripped away, and he was alleging it was because of his position on this on the issue of wokeness in the college.
So let's stop for a moment. So in order to bring a claim arising under the federal civil rights statutes, in this case, this is probably a claim under 42 United States Code, Section 1983, which permits a person to bring an act against a state actor who acts in derogation or against their constitutional rights. You have to suffer some adverse action. And that adverse action could be loss of a job, it wasn't here, or loss of terms and conditions of employment. And so he was kept from certain committees, and he claimed it was based on the content of his speech, that state actors, that is North Carolina state administrators, removed him from certain rights and responsibilities because of his speech in violation of the First Amendment.
And just to be clear, and I can bring the opinion up here in just a moment, but he was concerned, and it even talks about it in the majority opinion. He was concerned that stripping him away of involvement in these certain things would end up in a termination of his tenure, because it actually precluded him from being able to advise students. If you took it to the logical extreme, his inability to be a part of certain segments within a department, or sort of, I guess they would call it areas that they like subject areas within that larger department. He wasn't able to be involved because they stopped inviting him to certain things on purpose. And he was saying when it came time for evaluations that over the course of the next couple of years, if everything matriculated with the same momentum that it was having, and he expressed this to his direct superior, who I guess left the university before this stuff ripened. He said, my concern here is that I'm going to lose tenure because the university is going to eventually come to an evaluation that says that I am not fulfilling my role as a tenured professor because I'm not able to fulfill my role as an advisor to these
Well, that's a
doctoral
different, yeah. So that raises the related question of ripeness. I mean, should he have waited to bring this claim until he lost his job? He didn't. I think he had an adverse action claim preliminarily to that because of his loss of access to rights and responsibilities.
Well, Norm,
but let's focus. Let's focus on the First Amendment issue. The First Amendment issue is: was the university justified in taking any adverse action against him at all? Whether that adverse action was going to result in his loss of tenure or not. And the Fourth Circuit surprised us. What was the decision, Mike?
So this is the interesting procedural thing for me, Norm. This was a motion to dismiss. This was the university's motion to dismiss 12B1 and 12B6. And
well, you use these numbers. Tell our readers what they are.
At the pleading phase, defendants in a civil action have the ability to make a motion to dismiss. And under the federal rules of civil procedure, it's rule number 12, subsection B, and then there's a list of subsections underneath 12B that give reasons that a claim may be dismissed. The most common among that list of reasons is a 12B6, or a failure to state a claim upon which the court can grant relief. And this, whenever a party moves for a 12B6, it's for two reasons. One, it's sort of lawfare, right? It's strategy. Let's see if we can't dispense with this case early and often. Let's force the plaintiff to spend money, right, and invest time and resources into defending against the various motion practice, oral arguments, etc. And the other is just for good faith reasons to say a zealous advocate for a defendant is going to try and dismiss a lawsuit at every available stage.
But
right?
more to the point, 12B6 basically means failure to state a claim. And so in law school, in civil procedure, once we learned that, and if we thought somebody in class was being an idiot, we'd shout out 12B6. But from a procedural posture, the person moving to dismiss has to accept as true everything that is alleged in the complaint. There's no discovery. The well-pled allegations in the complaint are regarded as established. What happened here?
Well, that is actually something that was brought up in the dissent. But yes, it's if you make just to state what you said again, when a court looks at a motion to dismiss, the moving party necessarily says all reasonable assumptions or all reasonable conclusions can be made in favor of the non-moving party. So here that means NC State says, court 12B6, failure to state a claim upon which relief can be granted. You may accept as true everything as alleged in the complaint, and we still win as a matter of law. They have failed to satisfy the basic fundamental foundational elements of the claim or claims that they have brought here.
And what's the 12B1 motion?
12B1 is an issue of jurisdiction, right? And 12B1, I think, is related to the sovereign immunity and related specifically to the monetary damages claim. So the court dispensed with that pretty early. That was
okay. Let's move on. We'll get with that another day.
I don't want to get sidetracked, but the 12B6 is exactly what this is all about, and that's why Professor Jonathan Turley here is calling this, the most chilling of free speech decisions or First Amendment decisions in and among recent memory. And it's simply because at this early phase of pleading, it is almost unconscionable for the court to make a conclusion of fact that a causal connection has not been sufficiently alleged in the pleadings. Taking everything as true, the court ruled that Professor Porter's speech was not protected speech within the boundaries of the First Amendment because it was made in his capacity as an employee. And there are various examples of the speech that he cites, but most notably a blog post that went viral back in 2018 where he called what was going on at a certain conference related to the education in academia. There was a conference called, I think, ASHE, A-S-H-E, and he said he was not participating, that it was a woke joke, and that he would only go to these things if he thought that the speakers were smarter than him or there was something more valuable for him to glean, and that's why he hadn't been in the last several years. This went viral, and the court somehow said that even in among the other anecdotes and the other evidence that he presented for speech that could have been classified as protected, aka not within his official capacity, not as a made as a matter of public concern kind of thing, they still found that all of this conduct at this preliminary phase, Norm, this is why it's so absurd.
And I hear you.
When every inference is supposed to be given to the plaintiff, that they couldn't come up with some sort of like plausible causal connection between.
Well, I think the case is, the case is going to be ripe for Supreme Court review because, basically, so the law of the First Amendment says that just because you're a public employee doesn't mean you can say anything you want whenever you want. Your employer has the right to regulate your speech, but it can't regulate your speech for the wrong reasons. And so the test for determining whether it's employment related or not, and therefore unprotected, or employment related but protected, is whether your speech raises an issue of public concern. In this case, the Fourth Circuit used a new category, one that I've never seen used in a First Amendment context. And it said this guy's speech was so flip that it reflected a lack of collegiality. And so he wasn't disciplined, or the adverse action wasn't taken against him because of the content of his speech, but because of how he said it. And the collegiality standard now adopts and enacts what I will call the Grey Poupon standard of getting along in academia. If you have principled disagreements, you must say, please pass the Grey Poupon. You can't refer to it in ways that might offend your colleagues. And I think that let's keep an eye on this case. I think it's likely to make it to the Supreme Court.
Oh, I think that there's no question, especially with the swiftness with the Fourth Circuit ruled in favor. So the district court granted the motion to dismiss, which, that was a federal judge out of the Eastern District of North Carolina, Judge Boyle, who I've appeared before in a First Amendment case. I was surprised to see them grant the motion to dismiss on these grounds. This panel, this Fourth Circuit panel, 2-1. What I have on the screen is an excerpt from the dissent by Judge Richardson on the Fourth Circuit bench. And he says, quote, unquestionably, there has been a growing and wide-ranging public debate about how colleges ought to emphasize diversity, equity, and inclusion. Though the exact words Porter used in the faculty meeting are not in the record, reading his complaint in the light most favorable to him shows that its subject matter was well within the realm of this public debate. And anything that, quote, involves an issue of social, political, or other interest to a community, end quote, involves a matter of public concern. Thus, because Porter made his faculty meeting comment as a citizen, and because it was on a matter of public concern, protected speech. Now, just to be clear, this is the dissent. So this is not what the court found.
And I found
exactly the opposite at this preliminary phase. So two huge issues here, right? It's not protected speech, and therefore it goes to a lower level of scrutiny in terms of what NC State is bound to legally. And I think that the dissent here is right. I think Professor Jonathan Turley is right. I think that the court here did backflips to protect this institution. And Norm, this is my alma mater. I talked to you earlier this morning. My time at NC State as an 18 and 19-year-old was embattled. And it's interesting because, I graduated high school in 2008. I graduated college in 2012. And even then, even in the humanities and social sciences realm and in the undergraduate realm, generally speaking, this stuff was beginning to become ubiquitous in those fields of study. And I was very detached when I got there and realized that academia had really succumbed to this rule following, this sort of very prescriptive education facade rather than legitimate critical inquiry. And it wasn't until certain other exogenous circumstances in my life that I was able to kind of jog myself awake and say, all right, play the game, get through this, and don't fail out, right? But it's interesting that this case is as recent as 2021. This guy was hired in 2011 as a tenured professor. So he's on the
cutting edge. He's on the cutting edge.
See the evolution of this issue, and his major issue, or one of the major issues, was how the institution was trying to, I guess, separate certain paths of doctrinal matriculation, but and based on certain criteria, but then really administratively they were the same thing. and they were
Well,
trying
let's
to
pivot.
place people in
I think
positions, etc. Anyway,
Yeah, let's pivot. I mean, we've crystallized the issue. I mean, this collegiality standard, whether it was appropriately applied in the context of a motion to dismiss, is going to be up to the Supreme Court. I think the case gets sent back for further proceedings, and that he did speak out in public concern. I agree with you. The dissent is right. NC State apparently, or was it the UNC in general, made an interesting DEI rollback yesterday. It's not going to compel people to engage in collegial speech, or that's one argument. It's not going to compel people to state that they support broadly DEI objectives. So one employment application question would be to ask a person, what have you done for DEI world lately? And so the courts have concluded or the UNC system has concluded that it's going to pause this. Candidly, I don't understand that. I think that is an objective that the university can pursue. And I think it's a fair statement, a fair thing to ask an applicant. I don't think an applicant who says nothing or I refuse to answer that question should be denied employment on those grounds. But I was a little bit surprised to see UNC roll this back. I think that's an overreaction to last week's case in the Supreme Court. Compelled speech is when the government forces you to do something against your will. So, for example, you can't force a child to say the Pledge of Allegiance. That's compelled speech. You can't force an employee to say Black Lives Matter or Black Lives Don't Matter. That's compelled speech. But I do think employers can ask employees about their attitudes about issues and their behavior involving topics that are likely to be be to employment. And DEI was not thrown out.
Yeah, but in this context, so this is the hiring context, right?
Right.
This is also, but the call of the question for these applications was asking the applicant to talk about how they had furthered diversity, equity, and inclusion in their life, which is sort of rubbing that line. It's less about a sort of an objective inquiry into the mind of an applicant, and more about, how can we weed out somebody? Because if you reject diversity, equity, and inclusion as some sort of criteria.
Yeah, I hear you. I just think UNC
that puts you in a weird position.
I think UNC's. I don't think it's compelled speech to ask that question. I think it's discriminatory to not hire, depending on the answer. So I think the geniuses in the legal department at UNC are slightly out of focus on this issue. It's interesting though that at the very time that the Fourth Circuit is saying as to NC State. You got to be collegial with respect to woke topics. Another flagship institution in North Carolina is backing off, suggesting once again that North Carolina is at the center of all things related to our fractious political climate, and suggesting further that lawyers and law students need better education in this material, which is why Mike and I are issuing a call to all law students. We're asking you to send us your syllabi, your orientation material, anything you're getting for your first year or even your second or third year of law school, because we want to maintain and develop a presence in the law schools of this country so that law students have a place to go to get a critical perspective on what they're being taught. We don't want you to become wokeocrats. We don't want you to be afraid to speak out on matters of public concern, as Professor Porter undoubtedly will be henceforth. We want free speech to matter. We want the full range of ideas to matter. So if you're getting ready, if you're a rising 1L, what does that mean? It doesn't mean you're a loaf of bread in the oven. It means you're about ready to enter your first year of law school. If you're a rising 2L, that is, you're about ready to enter your second year of law school. If you're a rising 3L, that means you're about ready to enter your third year. Send us your material. We're going to be developing content directed toward law students. We'll see where this goes, depending on the reaction. We may have separate breakout sessions. But I've spent some time tutoring law students in recent years and have been shocked by what I've heard is what's going on in campus. And one of my great joys as a tutor of law students is to give them questions to ask their professor. Those questions are designed to blow up the classroom discussions and to provoke a diverse point of view in face of a woke orthodoxy that appears to be crushing dissent and wants to have it one way and one way only. So keep an eye on that and give us your material.
Absolutely. This is live on Locals, this article. I will be publishing this to Twitter shortly as well. So please head over to Locals if you're not already subscribed there. Hit the red button, click join, become a member, and consider becoming a subscriber. No matter what, you can freely share this across your own networks, whether it's just directly through email, whether it's Twitter, Facebook, Instagram, whatever you're using. Read the article, share it. There's a reading list in there, or at least the beginnings of a reading list in there. We do want to see the syllabi, but Norm also suggests as required reading Locke's second treatise on government and certain questions you should be asking yourself while you're reading that. So please head over to lawandlegitimacy.locals.com. You read the article. You can go to @Pattis Podcast here shortly. That'll be published there. And we look forward to getting the emails. I put the email right here at the bottom of the screen, pattispodcast@gmail.com. So if you'd like to email, ask questions, even if you'd like to contribute anonymously, I think Norm, you've invited that. You can write and pin stuff to us either pseudonymously or anonymously. We'd love to have that as well.
So, folks, I got to run. Trial beckons. And, I'm hoping the jurors are thinking what I'm thinking right now. Why did the state bring this stupid case? But we'll find out soon. I think closing arguments will take place tomorrow. Thank you all for tuning in. Mike, how do people find us?
You can find us on Rumble Video at Pattis or at Law and Legitimacy rather. Twitter at Pattis Podcast. YouTube Live. We're at Law and Legitimacy. You can always find us on Apple Podcasts, Spotify, Google Play, Overcast, Audible, etc. Wherever you find podcasts. All we ask is that you gift us a retweet or a like or a share or a subscription, or rate us 5 stars. And we're here every morning at 8 a.m. Eastern Time, Monday through Friday. Norm, glad to have you back. It's fun sometimes flying solo. You get to do some backflips, but it's nice to have a co-pilot as well. So nice to have you back.
Thank you. Thank you, everyone. Tune in tomorrow. We'll be back.
Sounds good. Bye, Norm.